This video is a summary of changes to the Tier 1 investor category, which came into effect on the 6th of November 2014. There are 6 main points to go over, so I'll go over the changes now. First of all, the investment threshold is being raised from £1 million to £2 million. Secondly, 100% of the funds must now be invested into UK government bonds, share capital or loan capital in active and trading UK companies. Prior to the 6th of November, it was possible to invest only 75% into these 3 investment types, and the remaining 25% could have been invested into property. This is no longer possible. Also, the term active and trading in the UK for a company is being defined formally for the first time within the immigration rules. There are 3 criteria which a company must meet to be considered active and trading in the UK. First of all, there must be a registered office in the United Kingdom, so this could be a head office, for example. There must be business accounts showing recent business transactions. And thirdly, the company must be paying taxes in the United Kingdom as well. The fourth point is that it is no longer necessary to top up an investment if its market value falls below the minimum investment threshold. But it is necessary to top up where part of the investment portfolio is sold, and this can be done by purchasing additional qualifying investments. Essentially, this point was introduced with the intention of encouraging Tier 1 investors to venture into riskier investment types where there might be a greater yield, but where fluctuations in the market would not affect their Tier 1 investor status. The fifth point is that loaned and leveraged funds are no longer permitted. And the sixth and final point is essentially the introduction of a subjective element into what was previously a relatively objective, points-based application process. Specifically, the Secretary of State now has discretion to refuse an application if the funds being used for the application are not under the control of the applicant, or if the funds were acquired unlawfully, or via means which would be considered unlawful had they been employed or had they occurred in the United Kingdom. Also, if a third party is contributing to the funds being used for investment, and where the conduct, character, or associations of that third party are such that approving this application would not be conducive to public good in the United Kingdom, then an application may be refused on that basis as well. Most of these points, in fact, the first 5 points I described, are applicable only to applications made from the 6th of November 2014 onwards, so they will not apply to those who entered the route before that date. However, the last provision, the one regarding the new powers of discretion bestowed upon the Secretary of State in relation to the origins of funds being used for investment, that provision will apply across the board, regardless of when somebody entered the Tier 1 investor category, whether it was before the 6th of November 2014 or afterwards. And that's it. I hope you found this information useful. If you have any particular questions about the Tier 1 investor visa or maybe about your specific application, then please don't hesitate to contact us.